Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, today we are going to have a chat about a group of companies, and it's a group of companies that operates an enterprise that includes some car sales, so some car yards and the property owned by those car yards. It includes some other property investments and some other potential holdings into the future. And it's a group of some value, probably in excess of several $100 million. What we have today is we have a dispute between a group who we're going to loosely call the plaintiffs and a group who we're going to loosely call the defendants. And if you and I can just sort of rub along together and understand that each of those phrases refers to a number of different people, it's all going to make sense in the end, I promise. One other thing I should say is I'm wearing sunglasses, firstly for the glare, and secondly because I have what I think is called a sty. So for anyone curious, looks like I've been punched in the face by a very small, weak person, which very, very rarely happens, but we'll solve that another time. But in any case, here we are talking about this entity. Now, the plaintiffs, broadly speaking, are a generation of people who we're going to loosely think of as our aunts and their related entities. And the defendants, who, speaking loosely, we're going to think of as our nephew and some of the relevant related entities. And the whole group was set up, loosely speaking, by Grandad, who we might think of as the patriarch and kind of driving the setting up of the business back in the past. Now, we have a background to the sets of facts here where there are some back and forth about negotiation of an exit. It sort of becomes clear over time that the relationship between our plaintiffs and our defendants is not particularly constructive, even though the business is making money and ticking over and it's valuable and that sort of thing. The relationship is reasonably sharp. And what we have from around about the year 2017 and ongoing for the next few years is a number of offers to sell, offers to buy, and essentially offers to kind of bring the group to a close to have a kind of commercial exit for people to get their money, or in the alternative, for one group to buy out the other. And so these things are bubbling along in the background. The offers, as it were, that are rejected, and this kind of tension where we have the intergenerational disagreements going on. Now, the real thrust of our discussion today revolves around two things. Firstly, the defendants, who we'll speak of loosely as our kind of nephew group, causing a new trustee to be appointed in respect of a significant portion of the group. So removing the existing trustee and putting in the nephew's choice of trustee to take control of that group. Now that's something we're going to dive into a little bit more deeply, and that's one area for dispute, and that's where our plaintiff aunts have kind of their big problem. That's their main application and their main concern. What happens very shortly after that is that the nephew, who is also the CEO of the group, is terminated. Their role as CEO is terminated and they are removed as director from a number of entities, and that action is taken essentially by the aunt group over here. And so we have the claim brought by the aunts that says you shouldn't have removed our trustee, and then we have the cross-claim brought by the nephew who says you shouldn't have fired me as CEO and director. And that's essentially the nature of what's being determined in this dispute by the court. And so let's try to work through some of the machinations of it together. Now, do you remember I said that the aunt group was frustrated or concerned or seeking to challenge the appointment of a new nephew-friendly trustee in place of the old whole group-friendly or maybe aunt-friendly trustee that we had in place previously? Now, as you may well know, the person who appoints a trustee is a person called an appointor, aptly named. And so in about 2017, our nephew, the CEO, causes a bit of an audit to be conducted about the group. And it's a group that's been in place for decades and decades at this stage. And so you might have a director of a sub-company, Jay over here, who turns out to be a long-lost uncle who's actually passed away, or a company over here that's the beneficiary of some commercial trust that turns out to have been deregistered, or whatever. It's the kind of process that lawyers go through to look at a structure and make sure everything's kind of up to date. And so there's a law firm commissioned to do this, and one of the outcomes of that is that there's a suggestion that our defendant's nephew is going to be able to put in place a new appointor for this relevant trust. And so the nephew says, yeah, okay, go ahead please and prepare the relevant documents for me, and I'll need to understand what goes on in relation to the appointment of the placement of a new appointor, in order to then use those powers into the future. And the nephew has a number of questions, should this be a chair, or like what sort of parties can it be, and what are the documents that I'll need, and this sort of thing. And there is this meeting set for 1 May 2017, and this is kind of the really operative meeting, because if we flash forward before we flash back, it is this meeting that our defendant says, yeah, I'm the nephew, that's the meeting where I became appointor, and so after I became appointor, I had the power to appoint a new trustee, and because I became an appointor on 1 May 2017, any time after that, I had the power to put in place a new trustee. And so when I exercised the power to get rid of the aunt-friendly trustee and put in place a nephew-friendly trustee, that's fine, because I was the appointor and I had the power to do that. That's what the nephew said. Now, do you remember I said we had concerns about this 1 May 2017 meeting? In essence, the aunt, and it's necessary for the aunt to be there to approve the placement of the new appointor. Think of it something similar to a quorum, but not quite the same thing technically. The aunt has to be kind of present and approving of putting the nephew in place. And what the nephew says is, yeah, the aunt was there back in May 2017, and so yeah, I was put in place as appointor, that's fine. Now, through the mists of time, there are a number of different versions of the minutes of this meeting that don't seem to include the aunt on kind of the first draft of the minutes. And there are a number of, as I say, different versions of how these minutes look. One of them is a fairly bland, entirely printed version that doesn't have the aunt present. Another is one that does have the aunt present, and the aunt's presence is noted in the nephew's handwriting. And another one is similarly without the aunt present and the nephew's handwriting and it being slightly different. And so we have these kind of competing versions of the record of this 1 May 2017 meeting. And don't forget, this is the meeting, the nephew says, that's where I became appointor, so that's why it was fine for me to put in place my trustee. Now, I'll just spoil the ending and say, the court found, looking at the various different versions of these documents, noted that some of the documents were created in 2024, and there was this strange evidence from the nephew about why he would have been carrying around these minutes and why some minutes would have been, in this office in the CBD, not that office in Blacktown, and it all seems a little bit fuzzy. These are in circumstances where the aunt says that they didn't attend and they didn't agree, and in essence, the court finds that the aunt did not attend this 1 May 2017 meeting, and so the plaintiff was not validly appointed or validly put in place as appointor, and so any steps that the nephew as appointor purported to take would be invalid, and so the nephew's appointment of the nephew-friendly trustee of the significant part of this group falls away. So the aunts, as it were, succeed on that trustee point. Do you remember how I said that after the aunts found out about this trustee point, they removed the nephew as CEO and they removed the nephew as director as a number of the various sub-entities? The nephew challenges this on a number of bases. Now, firstly, the nephew says, hey look, gets into this issue about whether a written contract applied. There's this older written employment contract that the CEO says, oh, that's back when I was deputy CEO. Time's moved on, my working conditions have changed. That's really not for this current role, and so it doesn't really apply to my role as CEO, and so we shouldn't be looking at those terms. It's more like an unwritten sort of employment arrangement. In essence, the court doesn't accept that, but it's not an absolutely fundamental issue. The real point here for the court to look at is whether the termination was a genuine, kind of well-founded termination, or whether it was essentially a ruse for the aunts to be like, we're firing you as CEO, or we're causing a number of these companies, using our position as directors of a number of these companies, we're going to cause you to be fired as CEO. And what the nephew says is, that's just a ruse for you to trigger some pressure to be able to be applied to me to sell my shares. And what you really want is not to fire me. You don't care about whether I'm employed or not. Your whole motive for terminating my employment is so you can get at my shares and you can go ahead with this big sale. That's what you're trying to do. And so the court has to look at whether the termination of employment was actually justified, and looks at the letter of saying, hey, you're terminated for reasons 1, 2, 3, 4, 5, and essentially finds, yes, indeed, it was a legitimate termination because the aunts, as it were, or the entities engaged by the aunts, had lost trust and confidence, and had legitimately lost trust and confidence in the operation of the CEO. There's a number of reasons for that. And the CEOs of bad mouthing the aunts to kind of third parties. A lot of these car manufacturers, right? You've got to be friends with car manufacturer A, car manufacturer B, car manufacturer C, if you're going to be running one of these enterprises successfully. And so the CEOs off there bad mouthing their aunts, saying, "Oh, the aunts are related to bikies, and the aunts are in the way, and I don't want you talking to them." The nephew's also stymieing the aunt's ability to conduct any real management with the group at all, and directing staff, don't talk to the aunts, don't answer calls from them, don't give them information. And so the court finds, it's pretty clear why the aunt-related entities or the aunt-controlled parts of the group did lose trust and confidence in the CEO's ability to perform their role. And so it was a legitimate termination from an employment context. Not satisfied with just raising the employment issue, the CEO nephew also says, hey, it was also corporate oppression, right? I was fired in order for the aunts to be able to get a bit of leverage to get me to sell my shares or get the relevant corporate entity to sell its shares. And so there was no appropriate basis for the termination. It was oppressive or unfairly prejudicial within the meaning of Section 232 of the Corporations Act. And the short point is the nephew fails on that point as well. It's a reasonably long judgment. We've just scratched the surface there, but I hope it assisted you in understanding the position. And what you might have noted is the aunts won, nephew lost, and so costs followed the event. So the final orders to be made in this matter will be that the nephew will be bearing responsibility for the legal costs incurred by the aunts in these specific proceedings. Now, sadly, with great respect for the parties, there are sort of a number of other relevant pieces of litigation, and indeed for this group of entities, we've done a previous case note on this last year that I can link you to. But short point is, I hope that discussion assisted you, and I look forward to joining you again soon over another coffee and in respect of another case note. Cheers.